Hello, welcome to ProBono, sponsored by Cohoon Legal. I'm your host, Amber Cohoon. I'm an attorney in North Texas, and there are new podcasts available monthly. You can subscribe on most podcast platforms and find us on social media. Follow us at ProBono Show. Remember, this podcast is for informational and educational purposes only and should not be considered legal advice. It is not intended to replace professional legal advice. This information is catered towards Texans with a focus on Texas law. What we have for you on today's show is we're going to cover some employment law topics. The first we'll cover is an offer letter. Severance negotiation will be next. And then we're going to go over some common employment law questions for our audience. And then we'll discuss some resources available. Also, because employment law is changing so frequently, it is always important to seek out legal advice for your specific situation. And do not procrastinate. In employment law, there are very short deadlines for acting on your rights. And if you miss them, you may be barred from asserting any claim at all. So reach out to an employment lawyer near you for advice. So you've interviewed and you've been offered the position. And then you get an offer letter. And I want to talk about what an offer letter is and what it isn't. So an offer letter generally will include pay and the frequency of the pay periods. It will include usually any benefits you'll receive. And then if there are any bonuses or commission for your specific position, usually the terms of those and the details will be included, and it will have your start date. In Texas, it will often include a statement that you are an at-will employee. Unless you have a promise to be employed for a specific period of time at any employer in Texas, you are by default an at-will employee. Most people are an at-will employee. So if you're not sure, you can always ask, but usually you are. Where there's a difference is that some people will actually receive a contract for employment. That will have more explicit terms for the employment. It will actually have the period. So maybe you are a teacher or professor, and so you will be employed for the term of, the fall of 2024 to the end of May or spring 2025. But it will have specific dates for the employment, and it will also include provisions about termination and what will be a termination for cause in that employment agreement. And it will not say, usually, if it's written well, it will not say anything about being an at-will employee. And the reason I say it shouldn't say that or it won't is because there are often employment offer letters that are not maybe written in the most legal way. And so it might have some contradictory terms. And so it's always best to have that reviewed. Even if you were to get verbal confirmation from the employer, what really is important is what is written down. And so where the big difference is that one of these types of agreements, usually the employment agreement, but it doesn't necessarily have to be called that, it's a binding contract. And then just an offer letter, unless it has other specific terms that would make it binding, it isn't binding. And so an employment agreement, which is binding, can actually be sued upon if there's a breach, if there's a term, or if they fire you. I'm not saying that you can't be fired, but if there is a term or provision in the agreement that they do not follow, that can be ripe for a lawsuit for a breach of contract. The offer letter, as I said, is not binding, and those terms can change. For instance, if the offer letter states that you will be paid a salary of $70,000 per year, and at a future date, that means that there's nothing that would prevent your employer from either raising or lowering your salary. Most people don't ever have a problem about a raise, and they don't have questions about when that will take effect. That usually is more excitement rather than concern. But there are times when you might be notified that your salary will be lowered. And I've gotten quite a few calls about that where people are concerned that, can they do this? And so the only thing that would prevent them from making a reduction is if it's retroactive. So let's say that you have been working at the $70,000 salary rate and you've been paid for the pay periods up through March 1st. And on March 1st, you were notified that your salary will be lowered. Well, after that March 1st date, they can do the lower salary. But if you haven't been paid, let's say you are waiting for a paycheck and your paycheck's going to be on the 5th, and it's going to cover through that March 1st date. Well, through that March 1st date on that paycheck, you should be paid at the higher $70,000 rate. But then the days after, it can be at the lower rate. So as long as it's not retroactive, then it is legal. They can actually make that change. Another thing to consider is that if once you're made aware of the change and you continue in your employment, then Texas law considers that you've accepted it, because you always have the option to quit and leave your employment. Another thing about an offer letter that would make it binding, as I kind of said before, is if it had similar language to what we talked about for an employment agreement, where it has an actual specific term and a length of term. Now, it may say we plan on you being here years or, through the school year, but it also will have at-will language. Those are, that can be kind of confusing. So it probably will be an at-will, but you do always want to get that reviewed just to be certain. Another thing I want to talk about, which I handle quite frequently, is that severance negotiations. So I handle employment law, but I handle a very specific area of employment law in my law firm, and it is where I assist clients. Usually they're very high-level employment positions, maybe president, vice president, or C-level type of positions. Those positions usually have severance negotiations. Not always, but they usually do if they're terminated. And so that's a contract that has the effect on your future employment potentially, depending on the terms. So in those positions, no matter what position you are, if you're an hourly employee or if you're paid, contract, as long as you are not an independent contractor. So those are different. That's not an employee. But if you're an employee and you're paid, a salary every month, whether it's, based upon minimum wage or higher, you have the same legal protections in the law for employment. But when you are at a higher level, oftentimes an employer will have you sign other agreements. And that could be upon hiring, or it could be during the course of your employment. And sometimes those are confidentiality agreements, non-solicitation, a non-compete agreement, non-disclosure. It could be compensation packages if you have bonus structures. It could be a whole host of different type of agreements that they have out there. And so it's always important anytime you sign a contract at any level of employment or in any area of your life to read through it. And if you don't understand it, please get counsel so you can understand the risk that you're potentially taking by signing and entering that agreement. So it's very common for a supervisor to present this contract or agreement for you to sign, and there might be an expectation that you just sign it. You just read it and sign it. Hey, I sent this to you, read it and sign it. Whether that is the expectation or not, you always have the right to have it reviewed. And oftentimes, when you read through it, you might actually come across a paragraph, it's usually towards the end, but not always, that will actually have language that says that you agree that you were given ample time to review it and actually had ample time for a legal counsel or an attorney to review it and explain it. It can be different type of language, but essentially that's what it's saying. And so when you sign that and enter that agreement without having it being reviewed, you're agreeing that that was correct, whether it is or not. And so always, if you have an agreement like that, say, hey, I need a few days to look this over, please, and I'll get it back to you. Or maybe ask, when do I need this back to you? It is so important when a client is given a severance package or agreement that they read it and that they are given advice by an attorney to understand it, because so much of the provisions and restrictions will have an impact on future employment or different endeavors that they do or their termination and what that looks like. And at times they may agree to a severance, and if they violate any of the terms, they will actually have to pay it back in what's called a clawback provision, where the company will actually say, well, you violated this, we paid you so that you would uphold this agreement, and now you owe us X amount of money that we paid you out. So that's not a good position to be in. So it's really important that you have it reviewed, you understand it before you enter into it. And again, you don't have to sign an agreement. Now, does that mean that you will always get to continue in your profession and your job with that employer? Maybe not. But those are choices that you make. And with all of my clients, I always say you have a choice. They may not be great choices, but looking through this agreement, this is what this means. This is the risk that you face if you sign this. And is it a good risk? Are you willing to take that risk? Or do you want to wait, maybe evaluate some other options to see if this is really, something you want to enter into? Because once you enter into it, there's no take back. You enter it into it, and that's the agreement you're stuck with. Unless there's a modification, and usually, and it'll say in the agreement that any modifications require the agreement of both parties. Well, your employer, why would they want to modify it? Once they have your agreement, they don't need any more. You have no leverage at that point. So once you've signed it, your leverage is kind of gone. You've agreed to it at that point. So when a client calls me and they have been given a severance, we look through the agreement, I have a consultation with them, and we discuss their employment history. Sometimes they've been employed for many years, and maybe due to their age, if they're 40 years or older, there's been some activity in the last year or two about how they've been treated at their job, which may raise the level of a discrimination claim, with age discrimination, if it's racial, ethnic. We'll go over the list of the discrimination later, but there might be a claim. We don't know. And usually the client isn't quite sure. Maybe they feel like something wasn't quite right, but without talking to a legal professional that is more versed in employment law, they aren't going to be able to make a good decision about whether or not they have a claim. And ultimately, a severance agreement, not only is it going to be paying you, for the termination, but it's essentially paying you to waive any claim that you might have. And you might not have any. And this might be just a standard practice of your employer to offer severance agreements, or they know you have a claim and they want to make sure that they get you to sign it so that you can't move forward with any claim. If there are any claims, then we discuss whether we want to, contact the employer to see if they would be willing to change the terms of the severance agreement. Maybe they want more money. Maybe they want to add health care benefits through the term. Maybe they want it paid out at a different rate. So these are all things that are automatically going to happen, but these are things that we can negotiate depending on the leverage that you might have. So it's always good to, like I said, talk through it with an attorney, but do not sign anything, because once you do, your leverage, you've accepted whatever amount it is, and you're releasing usually all claims that you might have, or claims that you don't even recognize that you had. And so if you're terminated and you were not offered a severance, that doesn't mean that you aren't able to ask for one. So it's something that I always encourage my clients to do, is once we talk through the issues, they can always go to them themselves and ask for a severance or ask for an increase. And sometimes I've had clients where they have been able to actually get it without the assistance of, actually legal negotiations that I offer. Sometimes they've gotten some, but then they wanted other, and so we did proceed forward. It just depends on your particular situation. And other times they ask and they're rejected. And then they come back and they say, well, I think that it would be better coming from an attorney, and I think I'd have more ability to get this increase that I'm wanting. And that can happen. So don't be concerned that you didn't get a severance. It doesn't mean that you won't be able to get one later. Doesn't mean you will. For my clients, I can never guarantee that we'll get an increase or a change in the terms, or if you didn't get a severance that you will get one. It is a negotiation, And depending on your situation, it might not be enough. Another thing to consider is that if you have a solid discrimination case, that isn't always the best place to do severance negotiation. It's good to talk to an attorney that actually handles EEOC and discrimination claims or sexual harassment claims, workplace retaliation, hostile work environment. Those are very specific areas of law that not every employment attorney handles. And you want to really get that evaluated, your situation evaluated, so that you know whether it would be more advantageous to file an EEOC claim and to see if you can get some sort of settlement in that way. Or EEOC claims go all the way through lawsuits. So that's something that you have to consider and talk through an attorney. Most of the time, attorneys that handle those type of employment discrimination claims, workplace retaliation, they usually do it on a contingency basis. So when you're evaluating an attorney, it's always good to kind of know your situation and explore how they structure their fees. If it's upfront, if it's contingency, what that looks like. And that's an important factor in determining what you want to do going forward. Some commonly asked questions about employment law in Texas are centered around Texas law and federal law, because there are federal protections under certain laws, and then Texas that has protections for employees. And so I want to talk about some of the Texas laws that we have. So one of them is called the Texas Payday Law. And this is maybe a lesser known law, and it's a very useful tool for employees that have been paid improperly or not received their pay check, or a number of different factors. So basically, the Texas Payday Law requires that employers pay their employees in full, on time, and on scheduled paydays. Now, Texas doesn't determine how frequent paydays can be. Most employers do either weekly, bi-weekly, monthly, bi-monthly, but they can do it as infrequent as quarterly or semi-annually or yearly. There's nothing that says in the law when employers have to pay, but when they determine when their pay periods are, then Texas says, well, you have to abide by that. The payday law helps employees who are not paid correctly. The payday law is administered through the Texas Workforce Commission. That website has a plethora of information for employees as well as employers, so that they can make sure that they're in compliance with Texas and federal laws. But basically, you want to talk to your employer about the discrepancy. So hopefully it can be solved in that way. But if it's not solved, or if they're like, yeah, I'll pay you, but it's going to be late, you can still file a payday claim. And that would mean that you are owed wages. So if you are owed wages, you need to act quickly, because you need to actually file the wage claim within 180 days from the original date that the wages were supposed to be paid. So if you're supposed to be paid on March 1st, and it is now April 1st, then you need to count from March 1st, the 180 days, so that you know when the deadline would be for you to file the claim. And claims can be filed actually through the Texas Workforce Commission website. What happens is that once you file the claim, the TWC will investigate it, and if it is appropriate, they will actually, it's not a lien, but they will get your compensation from the employer and pay you. Payday claims, it's important that you probably talk with an attorney so that they can explain the process and maybe your specific situation, but you do not need an attorney to file that. You can actually go to the TWC website, and they have a way you can file it online. Another thing to consider, and a situation that I had with a employee that contacted me, is that he was actually designated as a 1099 contractor. He did work by appointments, and he would go out to the customer's home, and he had equipment that he would service and would use his own tools, and I believe he had his own truck, and he would be reimbursed based upon a flat rate that they had, the employer or the company had determined. Well, what happened is he was supposed to be paid back. Maybe he was using tools or buying parts, and he was supposed to be reimbursed for those parts. And then, as well as they owed him maybe a month of money in the 1090, as a contractor. Now, normally a contractor does not actually fall under the Texas payday law. But in his situation, what we did is we looked at all of the aspects of his position and, how the employer governed or managed him, how he got his calls, what they paid for, how his day went, where did he start from? Did he start from his home? Did he have to go into, the employer's office before he started or company headquarters? We've looked at a variety of different aspects, and what we determined is that he actually should not have been classified as a 1099 contractor. He actually fell under the guidance from federal and state law to be considered an employee. So what that is actually called is a misclassification. And so what we did, and this is possible, is that I had to file a claim to have the Texas workforce look at his status as a 1099 employee. And what we alleged is that he was misclassified and that he should have been classified as an employee. And so there were federal wages, federal taxes, and Social Security and FICA, all that stuff that had not been taken out of his paycheck and paid properly by the employer. So once we did that aspect of it, and we informed them that he was an employee, then we were able to get the wage claim. And we were able to get the wage claim off of his back pay that he wasn't paid. The only thing that they weren't able to get was actually for the tools and equipment. So that would have had to be filed under a lawsuit. Depending on the amount, there is small claims, which in Texas, you can do a small claims case for $20,000 and less, or it would have to be in the district court if it was more than that. And so he was able to actually have the TWC fine that company and then pay him the amount that he was owed. Sometimes what can happen is if an employer is not paying you properly, it might be that they aren't paying many of the employees properly. And so when you file a wage claim, once that's done, the TWC has an immense amount of power to evaluate all of the payroll records. And that is actually what had happened, I believe, in that case. It's been a couple of years. But they were able to go back and they had quite a few contractors that were misclassified and they should have been employees. And so not only did they have to pay the wages that were still owed, but then they were actually taxed and they had penalties because they had failed to properly pay taxes. So no matter if the employer has said, oh, you're a contractor, this is how we're paying you, if the way that they act and behave falls under the factors for being an employer for an employee, then you're an employee and they're paying you wrong. And so the company, again, does not get to determine that because it's a way, unfortunately, that companies will do that because they don't want to have the burden of paying the employment taxes. So again, on the TWC website, you can file a payday wage claim. Similar to a Texas Workforce Commission unemployment claim, they have the ability, if you are owed and you file the claim and they deny it, you can appeal. There's a whole process and it's all on there. Probably the biggest area which is covered under not only federal but Texas law is employment discrimination. So employment discrimination is when either a job applicant or an employee is discriminated against based upon a protected class. And so that can apply in situations where in hiring, firing, promotions, if there's harassment, training, wages, and benefits. So it's something to consider. There's actually quite a few employment discrimination cases that happen for people who were denied hiring and they haven't even been employed, but certain actions by the employer led the applicant to believe they were discriminated against, and they filed an EEOC claim. With the EEOC, which is the U.S. Equal Employment Opportunity Commission, when you file a charge with them, what will happen is it will actually be sent to the TWC Civil Rights Division. Whenever you have an instance where you believe you have been discriminated against, it is very important to act quickly. So you have, in most cases, 180 days to file a discrimination claim with the EEOC or TWC. And that is from when it occurred. And what I've found with some of my clients that have these claims, but I don't do these type of claims. I usually refer them out. But what happens is they will look at all the activity, and sometimes the actions by the employer is an ongoing behavior. What you don't want to happen is that you have some discrimination occur on, one date, and then you file a complaint within your company, and then they do stuff to fix it, and maybe it doesn't fix it. And you let it go and you let it go, but it continues. But you really don't complain or do anything else. And it's been a year. And then all of a sudden, they decide to fire you. And by their actions and their words, it's very clear that they're firing you because of this previous discrimination or along the same lines. The problem is that talking with other attorneys that do this type of thing very frequently, is that the courts will see that that claim has been stale. So they really want to see that the action between when you're experiencing the discrimination and when you are filing or when you are bringing notice to the employer, it's within a 6-month period. And a lot of times employers know that if there's been complaints, that they wait. They're very aware of this, that about 6 months needs to go by, and a lot of claims will not really bear fruit for the employee. So you have to be proactive. The discrimination laws are, very complex and detailed, and it changes quite a bit depending on the courts. And so it's really important that you talk with an experienced employment law discrimination attorney that handles these type of EEOC claims. So let's briefly discuss the protected classes that the Equal Employment Opportunity prohibits discrimination against. And those include race, color, national origin, religion, sex, which includes gender identification and sexual orientation, age, which is over 40, and disability. Now, right now, evidently, the EEOC has a numerous amount of claims under the Disability Act, which is governed by the ADA, the Americans Disability Act. And that is a very special area of employment law. And so that's also something to consider, that not only if you're being discriminated against for ageism or being over 40 and you're being let go of your job, it's important to talk to an attorney that has experience in that area, because it's different from someone who maybe has more experience dealing with race or FMLA, so Family Medical Leave Act issues. The employment law area is so vast that it really, just reading articles and even going to the TWC can give you just a glimpse of your rights. The actions that your employer takes, which are actually prohibited, are unfair treatment based upon the protected classes that I listed. Also, additional to that is any genetic information, or if you're experiencing harassment by your managers, your coworkers, or others in the workplace. Something that people don't think about, if you're in a situation where you have vendors coming in, let's say, and the vendor maybe has commented in a derogatory manner or a racial slur or a sexist comment or something like that. You have the right to be, protected in your workplace. And so those type of actions, even though they're third parties, you need to bring those up to your employer. And so if harassment or retaliation, if you have made a claim to your HR or through the process that your employer has, and then you suffer from retaliation, that could be an illegal practice. Retaliation for filing different claims is protected. So you've complained about discrimination or some other type of act in the workplace, and then you're fired or you're terminated, you're demoted, all these things, you're passed over promotion. These are ways a company or employer can retaliate against employee. And so that also is protected. Another thing, if you're denied a reasonable workplace change because of your religious beliefs or disability. So under the American Disabilities Act, there's a lot of instances where you can ask for accommodations, and they have to be reasonable accommodations and something that your employer can do. And so it's so specific to your specific, situation. And I can't cover everything, but the biggest thing that I really want to stress is don't wait. Don't wait, because unfortunately, if you wait, you've passed that 180 days, your rights or your ability to make a claim through, with these laws are barred. You are unable to do it. And so you really need to act right away. There's other areas that may be prohibited. So the laws have stipulations about how many employees that have to be, 50 or more, depending on which part of the law. There's some that it's 15 or more. So there's so many aspects. Another thing that you need to think about, and what is a common question that I get when I'm talking to these people that have maybe experienced, discrimination or some other unpleasant work environment, is document. So document who you talked to, who spoke to you, what they said, when this occurred, who was around, were there witnesses? Are you aware of other people that have experienced this type of thing? You really need to document it. And so when people come to me and they feel like they're about to be terminated, or things just feel uncomfortable, you know what that feeling feels like. It's kind of in your gut that it's like, people are just acting a little strange. My manager's kind of giving me this, weird vibe, whatever that might be. Trust that. And it doesn't mean to say, are you going to fire me or anything like that? You need to be proactive to protect yourself, because at the end of the day, your employer is looking to protect itself. And the days of, making sure, that employees are welcome and everything's great for employees are kind of gone. I mean, we have good employers out there, but I would say they're few and far between, unfortunately. And so it's important to be proactive to protect yourself. So if you're hired and you get an employment handbook, you need to read it. Not only do you need to read it, you need to save it on a home computer so you have access to that. If you have any contracts that you've signed, you need to save that on a home computer, making sure that you have access to this stuff. If you come in one day and they're like, you're fired, you're no longer here, turn in your keys. If everything is on your work computer, all of the evidence that basically you've been discriminated against is on your work computer, that's going to be a really tough, a tough sell to any attorney, because you don't have the evidence. It's not impossible, but it makes it much more difficult. And so you really need to be proactive and document, as well as save those employment documents. If you have emails between your employer, which may be in the emails, they're saying these shocking, horrible things, save those. Another thing, in Texas, we are a one-party state regarding recording laws. So as long as you are in a conversation or in the room when a conversation is occurring, you have the ability to record it. You do need to look and make sure that you aren't violating any particular rule in your company, but generally, if you are in the room, you can report. If you're going to talk to your boss, you can report that. If you're going to talk to HR, you can report that. If you're talking to a coworker, you can report that. And you do not have to disclose that you're recording it. Another thing is that you don't want to ever leave a recording device to record people after you've left. That's illegal. So if you were in the room, if you're part of the conversation, you can record that conversation. So moving on to talking about, are you entitled to meal and rest breaks at work? So Texas law does not require an employer to provide a time for meal or rest breaks. If a lunch break is provided, the employer is not required to pay you for that break if it's over 30 minutes long, and as long as you're not working. So some people work through their lunch. That is determined if your employer, will allow you to do that or not. Some make you leave, some make you, take a break. I worked for federal government basically through the Small Business Administration, and we had to take a lunch. We didn't have to leave, but you were not paid for 30 minutes. So it would, to my benefit to leave and kind of get a break. And so it's really important that you find that out. It's usually either in your offer letter or it can also be covered in your handbook. But if they do decide to offer shorter breaks throughout the day, they have to abide by federal employment law. And the employer is required to pay for the breaks if they're under 20 minutes or below. So, going to the bathroom, taking 5-minute break, those are required to be paid. But if it's over 30 minutes, the employer is not required to pay those. So as I said before, there is a plethora of employment laws that cover you as an employee. And to cover all of those in this short podcast is not even feasible. And so we will provide many links and resources to the TWC website, the EEOC website, and numerous other ones that you can look at to learn more about your employment rights. And so as a rule of thumb, I have told many people that if you are experiencing, a new, not initially a promotion, but that a new change has happened to your company. So reorganization, a new manager, new president was bought out, whatever it is, be aware, be on the lookout, and be diligent to maybe start record keeping, because usually the people I talk to, it's been within a year or two that they find that they're terminated. Many of them are over the age of 40. So it isn't necessarily for all employees. And as I said, I generally help people at very high levels. So that is also a consideration. But it is something to think about if you're in those type of positions, you're at a high level, and there's been changes to kind of get your stuff in order so that you're prepared in case you find yourself in the unfortunate circumstances of being terminated. So normally I want to talk about something a little more personal. This has been a longer episode or a podcast than I normally do, and so I am going to keep it short. But I did want to share with you, I think I've mentioned before that I'm an avid reader, and that I actually like to write fiction. And for those of you out there that enjoy reading, there's a lot of good fiction books. I am not the best source of nonfiction. That would be my husband. But for fiction, I really like fantasy, romance, a lot of favorite authors I have. And so for those of you that do like to read, if you want some recommendations, there's so many great Facebook groups out there that are for different reader genres that you like. But one of my favorite authors is Susan Elizabeth Phillips, and she writes in the romance category. And I think I have read every single one of her books to date. Another author that I love, she's actually from the UK, is Sophia Kinsella. She was in more of a chick lit genre, but that has changed, and I don't know what the genre is now, but I would say it's more romance, but it's funny, very funny. She's one of the first authors that I was laughing out loud reading her stuff. So they both are great. They both are very witty authors, and I highly recommend both of them. So I hope if you like to read, you'll enjoy either one of those or both of those authors. Well, that's all for Pro Bono. Thank you for listening. I hope you have learned more about legal topics that can help you in your daily life. Please share this with your friends and family and send any questions that you have or ideas that you want me to cover in future episodes. And next month, we will be discussing real estate law. I hope to have a guest on, and because there's been some changes in real estate law, so we want to discuss that. Have a great day.